we suspect that the proposed amendment to bylaw 13-050 may impact the right of free expression as protected in the Canadian Charter of Rights and Freedoms. And the point I'm trying to make is not that it just limits freedom of expression. That, I think, is obvious. The point is that it limits free expression in a way that is more than necessary to achieve the objective of the bylaw. And for that reason, it is likely to be non-compliant with the Canadian Charter of Rights and Freedoms. Deeply flawed for the reasons I've discussed. It goes too far in limiting the right. And I would urge you to reject it and come up with a better solution to fight the pressing issue of discrimination.
So, Alan, you gave it your best shot, as did so many other persons standing up for freedom of speech, but it looks like Waterloo's censorious thugs, well, they were the ones triumphant. Your immediate thoughts?
David, I'm not surprised by what we saw yesterday at the Regional Municipality of Waterloo, because we've seen bylaws passed by city councils across this country. They're terrible bylaws. Sometimes, like in the case of Calgary, the bylaw does or at least permits, the exact opposite of what it's intended to achieve. And yesterday, I think we saw that the bylaw that the region of Waterloo passed exceeded its intended purpose. And to me, that's the major flaw with the bylaw.
And you know, Alan, why is it that suddenly municipalities across Canada, you mentioned Calgary, there's also Edmonton, London, why are municipalities which you would think should be concerned about, picking up the trash, fixing potholes, making sure the water is good to drink, why are they getting into the realm of free speech issues in the first place?
Well, that's a great question, David. And the fact is that that's not really part of their mandate to censor speech or to pass anti-speech bylaws. And one of the things that came up yesterday were some of the laws that we already have in place, which would restrict the type of harassment that people might experience on municipal property. You know, for example, we have criminal harassment, but we have less serious crimes like causing a disturbance. And that can capture the sort of scenario when somebody causes a disturbance by using offensive or obscene language. And then at the higher end, we have willful promotion of hatred. We have incitement of hatred. So why are these bylaws required? It's a bylaw passed by a municipality which tries to regulate private conversations. That's how far it goes. If you're on the bus with a friend of yours and you get into a debate, and that debate, maybe at some point you say something that's a little bit offensive to the other person, that can be captured by the bylaw.
And I note that the amendments come into force on January 1st, 2024. Happy New Year. And I see in a press release that you've sent out, the Democracy Fund will consider representing persons charged with this bylaw on a case-by-case basis. I guess that's what we have to wait for. We have to wait for somebody in the region of Waterloo committing a thought crime with an offensive statement, T-shirt, or placard, and then fighting that fine via the Democracy Fund, and maybe then it would be struck down. Would that strike down the entire bylaw, or would the bylaw still be there and it's up to the individual to fight it?
So, it's a really big question, David, and it really depends on how you defend the case, right? And so, sometimes you defend a case on the merits. You say that, the evidence is not there. At other times, you might want to bring a challenge to a court in a superior court of justice, for example, and you could ask them to strike the bylaw under Section 52 of the Charter, and they might just strike part of it, they might strike all of it. I suspect they would just strike the parts that offend the Charter.